My client, Andrew Wilson, was a passenger on an MTA bus, which got into a collision with a truck. We knew from the outset that he himself was innocent and that he didn't cause the accident. And that's an important starting point, because every auto accident or bus accident case starts with a question of who is negligent, who caused this accident. In this case, we know the plaintiff, as a passenger, didn't control either vehicle, so he couldn't possibly be found negligent. So that's a nice start. And then it becomes a battle essentially between the two defendants, the bus company and the truck company. This was a really long, drawn-out battle. Normally, you can have an agreement between the defendants where they say, okay, we acknowledge we have some fault, we acknowledge the other person has fault, let's come up with a percentage and let's divvy up liability. That was not the case on this matter. I had to try liability nearly to verdict. It was a 3-week liability trial, two very capable law firms, and they both told starkly different stories about how the accident happened, and they blamed each other. So of course, as we do in every case, we took the depositions of all of the operators of the vehicles, and we also took statements and depositions from the investigators from the MTA who came to the scene and rendered a report. They also took some photographs. I had a suspicion during the pendency of the whole case that we were not getting the full story from the MTA. So I repeatedly was requesting more photographs, more reports, and I was getting stonewalled by the MTA. And so that was during what's called the discovery process. And then when the case gets on the trial calendar, with defendants, particularly the MTA, I then serve trial subpoenas upon them. I asked for the very same information that I asked for during the course of the litigation's discovery phase. So I'm 3 weeks on trial, and every day I'm asking the TA attorney, who was a very capable attorney, may I please have a response to my subpoena? I have a court-ordered subpoena, meaning that the court signed off on it. The judge signed an order saying, give Mr. O'Toole all this information. 3 weeks on trial, they're not giving it to me. Every day I'm asking for a response. Finally, 3 weeks into the trial, I get a response. The defense attorney walks into court, he's got a big pile, and lo and behold, the photographs that he disclosed at that point showed a completely different story as to the happening of this accident, and it broke the back of the case. Transit Authority ended up paying 90% of the settlement. It settled that very day before any further testimony took place. And I learned a really important lesson on that case, and that is follow your gut, listen to your instincts, and make sure you get every single item of evidence that you possibly can. Don't give up on that pursuit. Don't leave well enough alone. Keep on pushing. In that case, my instincts were right. And I'm not saying it happens all the time, and I'm not suggesting that the defense attorney was hiding anything himself. I'm suggesting that when you have a big company like the MTA, some stuff gets lost. Sometimes the stuff that gets lost benefits that company. So your job as an attorney is to be a tireless advocate for your client and keep on fighting and keep on pushing and keep on asking questions until you get everything you need on a case. In that case, it made a huge difference in the outcome of the case. The case got settled within 2 hours of me pushing on that issue and finally getting it. I'm talking about a year I was pushing to get those items pursuant to subpoena. It served the client very well that I was tenacious on that case, and it gave him finality. And that's the thing that we really want for all of our clients. We want them to have peace. An accident takes away a lot of freedom for people that get injured. They're not free to do the activities they love to do. They're not free to do the activities they need to do to support themselves and their family. So I gave Mr. Wilson finality on that case, gave him enough money to give him options in life and provide him with security so he can provide for himself and his 2 young children. So that was a case that I feel good about. It was settled a long time ago, but I still remember the case to today.